Let's try another FedCiv Pro with different issues. And if you've read the description of this one, you know that we're going to be talking about compulsory joinder, personal jurisdiction, and res judicata. So get your outline out. If you've already memorized law toward a bar exam, okay. But better if you watch this with your own outline out and see how it lines up and matches up and whether it's useful for you when you go to issue spot a hypothetical. Because that's how you refine your outline. See if it helps you with an analytic strategy and if your organization and your rules make it easy for you to spot the issues and to be able to line up key facts. This has 3 calls. It's a federal civil procedure hypothetical, and that's obvious from the 3 calls. The first call was the federal court correct in dismissing the action on the ground of the impossibility of proper joinder of AmCorp. The second one asks about dismissing AmCorp from the action on the ground that it lacked personal jurisdiction over AmCorp. And the third one was about dismissing Big Corp from the action on the ground of res judicata. So right off the bat, let's take a look at each call in turn and what law would be needed for that call, so that when we go through the facts, we have the law in front of us. Call 1, about dismissing the action on the ground of the impossibility of proper joinder of AmCorp. What law is relevant here? We're talking about joinder of a party rather than a claim. AmCorp is a party to be joined to this action. When we're asked about the impossibility of joinder of a party, we're probably talking about compulsory joinder. What do I know about compulsory joinder? I know that I need to analyze whether AmCorp is a necessary party and also whether AmCorp is an indispensable party. So to be a necessary party, we have the rules here. Without the party, the court cannot provide complete relief, or the necessary party would be harmed, or an existing party would be subject to multiple or inconsistent judgments. And if AmCorp is a necessary party, then is AmCorp also an indispensable party? If a necessary party cannot be joined, then the court has to decide whether it can continue without the party or whether it should dismiss the action because the party is indispensable. And there are the factors to consider in deciding whether a party is indispensable. So we're going to look at the likelihood of prejudice to anyone if AmCorp is not joined, whether prejudice can be reduced by the relief that's being shaped, whether the judgment would be adequate without AmCorp, and whether the plaintiff would have an alternate forum to bring this claim. But notice that threshold issue in deciding whether AmCorp is a necessary party. A necessary party is one who's subject to service of process and whose joinder will not destroy SMJ. So we need to know what is required for SMJ. So back to the schema, we're looking at subject matter jurisdiction, and we're looking at original jurisdiction, concurrent jurisdiction, where the federal court and the state court both can hear the claim, and we're looking at diversity. And we see that we need 2 things. We need an amount in controversy, and we need complete diversity. Amount in controversy, a good faith allegation of more than $75,000. For complete diversity, we need no plaintiff domiciled in the same state as any defendant at the time the action commences. Domicile for an individual is different than domicile for a corporation. For an individual, it's one domicile defined as their true fixed place of residence where they intend to remain or to return after an absence. For a corporation, there are 2 domiciles, the place of incorporation and the principal place of business. All this because I can't establish that Amcorp is a necessary party without demonstrating that there was subject matter jurisdiction and that Amcorp does not destroy that. This is a big call. Back to the hypothetical, where we see again the second call is about personal jurisdiction over Amcorp. Let's look at the law on that one. So we're talking about in personam jurisdiction. And to analyze that, I need to talk about traditional bases for personal jurisdiction. Physical presence in the state, individual who is domiciled in the state, or consent. And then I need to talk about modern bases for non-residents. That means that I need a long-arm statute and we need to meet due process requirements. Long-arm statute, generally they give you a non-specific, or they don't tell you and you assume it's a non-specific. Due process. For that, I need to look at minimum contact, personal availment, and foreseeability of a lawsuit. This seems like a huge memory burden, doesn't it? Because there are a bunch of factors that go to the analysis of purposeful availment. But they're factors, they're not elements. You have to be able to recall them when the facts remind you of them. Then, when you analyze fair play and substantial justice, the same thing, a bunch of factors. But you don't have to be able to meet every one of them like elements, so you don't have to memorize them in the same way. You just have to know them well enough that the facts will remind you of them. So the goal is to have this structure in your mind when you take the exam. But there's another layer here on personal jurisdiction, and that's the difference between general jurisdiction and specific jurisdiction. If someone has so many contacts with a jurisdiction that we're going to treat them as if they were domiciled there, then the court would have jurisdiction over virtually any claim raised against them. But odds are, in a hypothetical on a bar exam, you're going to need to argue that there is specific jurisdiction because we're not sure there are enough contacts for the court to have general jurisdiction. Specific jurisdiction means that there's a close nexus between the contact and the plaintiff's harm. The law on personal jurisdiction is fairly complex. This is a big analysis as well. So I haven't seen the facts in the hypothetical yet, but it looks to me like calls 1 and 2 are both extensive calls. So back to the hypothetical, where we see call 3 about dismissing Big Corp from the claim on the grounds of res judicata. They were kind to you here. They could have said on the grounds of preclusion, and then you'd have to analyze both res judicata and collateral estoppel, but they have severely limited this call. I think this call is going to be the very short one. So when I'm mentally planning my timing, calls 1 and 2 are going to take most of my time. I think call 3 is going to be a much shorter one. But let's look at the law. We're talking about res judicata, or claim preclusion. The rule is that valid final judgments on the merits of a claim preclude relitigation, reassertion of the same claims between the same parties. So the key is the same parties. But there are elements here to analyze res judicata. Same parties, same claim, valid final judgment, and it has to be on the merits. Yeah, this one is going to be a much shorter call. They gave us very specific calls on this hypothetical, so we don't have to spot causes of action or grounds for dismissing the case. They gave them to us. They gave us all we need to specifically analyze the issues they asked us about. So let's go up to the facts and see what kind of facts we have that line up with the law we just took a look at. Law that you will have in your head in an organized way when you take the exam. I see that Big Corp is incorporated and headquartered in State B, so that's Big Corp's domicile. While in State B, Paul, a citizen of State A, so Paul is State A, was severely injured by a defective power saw he had purchased at a store owned by Big Corp in State B. Paul brought a products liability action for $100,000 against Big Corp in a federal district court in State B based on diversity of citizenship. That paragraph gave me all the facts I need to establish diversity jurisdiction over the original claim for the court in State B. It gave me an amount in controversy, and it gave me complete diversity of citizenship between Paul and Big Corp. As discovery proceeded, Big Corp disclosed that although it manufactures its own power saws, the particular power saw that allegedly injured Paul had been manufactured in State A by AmCorp. State A is where Paul is domiciled. AmCorp is incorporated and headquartered in State A, so there is not diversity of citizenship between Paul and AmCorp, and those facts establish that. AmCorp and Big Corp generally conduct business solely in their respective states, but sell surplus goods to each other twice a year. Those facts go toward a minimum contacts analysis for personal jurisdiction. The second call is about personal jurisdiction over AmCorp by the state court in State B. AmCorp does not do business in State B, but it does trade between a corporation in State B and itself. That is not enough contact for general jurisdiction. Is it enough for specific jurisdiction and for foreseeability of a lawsuit? Paul sought leave to amend his federal court complaint to name AmCorp as a defendant. Big Corp opposed the motion, claiming that such a joinder would defeat diversity, and moved for the dismissal of the action because of the impossibility of proper joinder of AmCorp. The federal court dismissed Paul's complaint. So you see what's going on here. The court had diversity jurisdiction over Big Corp in the state where the injury occurred, but AmCorp is domiciled in the same state as the plaintiff, and so joining AmCorp would destroy diversity jurisdiction, and AmCorp is a necessary party because without them the court can't provide complete relief. They manufactured the saw that injured the plaintiff. So if Big Corp can convince the court that AmCorp is an indispensable party and that they cannot continue without them, then they can get the case dismissed. So the big issue here is whether AmCorp is an indispensable party. Think about those factors that we had for indispensable party. Wouldn't Big Corp be prejudiced without them? The trickiest part of this analysis is realizing that they would not, because they can implead AmCorp. AmCorp would owe them indemnity, and a party brought in by impleader cannot destroy diversity. Paul then filed suit against Big Corp and AmCorp in state court, in State B. AmCorp filed a motion to quash service of summons, contesting personal jurisdiction over it. The State B court determined that it lacked personal jurisdiction over AmCorp and dismissed it from the action. Paul voluntarily dismissed his action against Big Corp without prejudice. So do you think that was correct? Did they intentionally place goods in the stream of commerce when they traded surplus goods with Big Corp? And was the defendant's contact, was the contact by AmCorp related to the plaintiff's injury? I think both of those are big yeses, so I think the court erred in not finding personal jurisdiction. Specific jurisdiction, probably not general jurisdiction. Paul then brought his products liability action in state court in State A, naming AmCorp and Big Corp as defendants. Big Corp moved for dismissal of Big Corp from the action on the ground of res judicata, and the State A court granted the motion. So think about that one. We have the same parties in both lawsuits. So that's not a problem. But we need a final judgment on the merits, and we don't have that here. We have a dismissal without prejudice, which means that there is no final judgment in this case, and Paul, in dismissing without prejudice, is entitled to raise the claim in another court and have it heard on the merits. So the court erred in this one. Okay, to sum up those calls, on the first call about proper joinder, I think the court could have found that Amcorp was a necessary party here. They were the best ones to defend their own rights, and there was complete diversity before they were joined. The hard part of this one is deciding whether they're an indispensable party. And if you don't think about impleader, then you might think that they were indispensable. But the problem is that Big Corp can implead Amcorp, and then they will be a part of the lawsuit, and they will not destroy diversity. So they are not indispensable. And the court should have proceeded. The court erred. Call 2, personal jurisdiction. I think the court erred. It did have personal jurisdiction over Amcorp. On call 3, the court erred yet again because there was no final judgment on the merits here. So my task for you is that you go back over all those factors and you decide what you would have interpreted as the correct answer for call 1 and call 2. I think there's no other interpretation for call 3, but call 1 and 2, do you agree with my conclusion that the court erred in each call? And is it helpful to you to see the way we organize law in our schemas? Does your outline look something like this? And do you want to continue to see the law in the midst of these debriefs, or is it just distracting? Give me some feedback, please.